lawyer, Mr. Desaikia. In item number 7, I'm handicapped today because my junior, who is in this case, has to leave for home because his father is ailing. So no sooner I will get him, I'll inform him, because I got another case in court number 1.
This is
So I
for
will leave for court.
this is Nagaland matter.
Nagaland matter, yes. So Desaikia.
We will not pass any order right now.
My lord?
Will not pass any order right now. Let
Yes.
the matter come up.
Yes. In the meantime, if I get free.
Even if we're not there, we'll see.
Yes. Well, 1 week time.
You can ask one of your juniors to be here.
Yes.
Yes.
May I please, Your Lordship? If I beg to mention for item number 28, we have filed an additional affidavit that may be allowed to bring into the record, Lordship. Deeply obliged.
Also, item number 51, Lordship. Lordship, I have said the service report is awaited, Lordship.
51.
51. After 4 weeks, Lordship.
51. Service report is awaited. List again on.
After 4 weeks, Lordship.
Give a date up to 4 weeks.
Time 20 May.
Oh,
May it please, my lord. My lord, I beg to make a mention in item number 46 of the daily list. By the last order, the petitioners were directed to take steps to Dasti. The Dasti affidavit has only been filed yesterday. That may kindly be called for. Deeply obliged.
Yeah, please, Your Lordship. I beg to mention item number 20. CD has not come today, so can it be fixed after 1 week? CD has not come. For item number 20.
Lordship, yes, charge has been filed.
Then in that case, Your Lordship may kindly call for TCR, because we are on a
Item
different.
20.
Yes,
Submitted the charge sheet has already been filed. Number is there.
Yes. Right, CS number 22/2026 dated 27/02/2026.
Hence call for the scanned copy of the TCR along with CD. List again on. Yes, next.
28 or 29.
Yes, please.
29.
I beg to mention item number 34 from daily list, my lord. This CD is available earlier, but contacting us on Mr. Azad Ahmed is after it's on my lord.
The prayer of learned counsel for the petitioner list the matter again on.
Next week, my lord.
CD is received. CD received be retained till then. Yes.
My lord, item number 55, this honorable court has directed to list the matter along with additional affidavits. But as per the office note, there is no record. So I may be allowed to see the defective, please remains on defective section. I may be allowed to pass it off for the day and maybe fix for.
Item?
Item 55, my lord.
All right.
Supplementary, sir.
Item 55
Lord.
on the prayer of learned counsel for the petitioner. List the matter again on.
Date may be fixed, your lordship.
8.
My lord.
May please, Your Lordship. Lordship, I beg to mention item number 26, my lord. CD is not available. Next week, my lord.
CDs are available, but that is lying in court number 8, Lordship. Next week, Lordship.
5th of May, my lord. 26.
Yes, these are all analogous matters.
Just Lordship. Till 26. From 22 to 26. All the matters may be come up together, Lordship.
All right, 20.
It may kindly fixed on 8th, Lordship.
I mean interim.
8th of May.
What about others? Are they on interim?
Stop interim or all are interim, Lordship. All are on interim. Lord.
All are on interim. 22 to 20.
26.
26. Okay, CD is not available today. List the matter again on.
8, Lordship, 8-5.
But if CD is lying in some other court, then
That's why, Lordship, let the matter come up on 8,
then where are the cases coming in different courts?
Lordship.
It should be listed before that. court only. All it will say be listed before the appropriate bench. List. List the matter again on so and so before the appropriate bench.
High level.
May I please, Lordship? Lordship, daily
Before
list,
that
I
you
think
write, CD is not available. Instead of saying CD is not available, you say it is submitted that the CD is lying in another court in connection with the same FIR. Hence list the matters on so and so before the appropriate bench. Yes.
May I please, Lordship? Item 42, Lordship, is wrongly listed in well hearing. It should be listed on motion. Kindly listing the motion.
40.
42, Lordship.
Two. Him has wrongly been listed at the bail hearing column. Place the matter in the motion column on. When? 27. 27.
Much better.
May it please your lordship. Like to mention item number 39. Looks, it was wrongly listed with EA 444 of 2026 instead of AB 39. Yes, Malas, that was wrongly done actually. Item number 40 is bail application 444 of 26. It should have been AB 446 as per the last order.
Item 39 and 40.
Only for 39, my lords. I'm paying for an adjournment.
Otherwise, CD is available in item number 39, Lordship.
It has to be tagged with AB 444 of 26.
440,
44.
it's there. Should be AB 444. Okay.
For item number 39, list. The item is wrongly listed along with bail application 444 of 26, whereas it should have been listed with AB 444 of 26 as per last order. Hence, list the matter again on 27.
Whereas date may not be necessary because AB 444 is listed today in court number 8. We'll take a date there. Then it may just be
Otherwise,
connected together.
in item number 39, CD is available.
No, no.
I think you reset. 40 is available, Lordship.
Item number 39 CD not available. And item number, although item number 40 is my lord tagged as with, my lord, actually both the cases are different police station. Item number 39 is Lahorigarh 1326.
40 is available. So we'll have not say anything about 40. We will simply adjourn 39 because CD is not available.
Yes.
39 CD not available, list again on so and so.
Well, date may not be necessary, my lords. Date may not be necessary because AB 444 is listed today before court number 8.
Then before appropriate bench, Lordship,
My lords.
Before the appropriate bench.
it would AB mobilized. If it is listed today in some other court, then this item number 39 should go to that bench, Lordship, appropriate bench.
Yes. I hope nobody is making a similar mention there that this case is pending here, so that should come here.
No, my lords.
And
It's
CD is
the
available.
same chambers.
All right, you cut all that, item 39, you write. It is submitted that as per last order, this item was directed to be listed along with AB 444 of 26. Full stop. However, today the case has been listed along with bail application 444 of 26. Full stop. It is further submitted by learned counsel for the petitioner that AB 444 of 26 is today listed in before court number
8.
court number 8. And the CD is also available in the said court. Full stop. Hence, as prayed for by both sides, transmit the records of the present case to court number 8 for the sake of convenience. All right.
Obliged.
Lordship, I beg to mention item number 50. Kindly pass over the matter for today, and Lordship allow some more time to take dusty service.
50.
50.
50.
50.
As prayed for by counsel for the petitioner, further to 2 weeks' time is allowed to take steps by way of dusty service. Place the matter again on 2 weeks episode.
Well made.
Yes.
I beg to mention, your lordship, item number 32 may be passed over for a date and may be fixed for 28 April. As the
Applicant's leave is available.
conducting counsel is out of station.
32.
32, item number 32.
32.
CD is available, Lordship.
Learned counsel for the petitioner. List the matter again on CD available. CD is available and same may be retained till then.
Applies to lordship.
May it please your lordship, I beg to mention item number 16. Item number 16, we have taken consent from the other side, lordship. 16.
Yes. The prayer of learned counsel for the petitioner and the consent of the other side list the matter again on.
After 2 weeks, lordship.
All right. Yes.
7 May, deeply obliged.
I beg to mention, item number 30, your lordship, CD is yet to come.
30.
30.
Right, 30 CD not available list again on.
Can it be listed on 28th of April, your lordship? 28.
All right.
Sir, it has been filed, Lordship.
Charge sheet submitted.
Yes. Item 30.
Then you say CS already submitted wide CS number.
White CS number 25/2026, dated 29/03/2026.
So what do you want to do? Appear or call for the TCR?
TCR call করবেন কি? Or you want to appear before the trial court, but TCR call করবেন?
I think instruction from.
Let the item come up.
May I please your lordship. Lordship, I beg to mention item number 31, my lord. My lord, due to personal difficulties of my senior, my lord, kindly the matter may be passed over to the day, my lord.
The prayer of learned counsel for the petitioner is the.
Any short date, my lord.
Iman,
Okay, highly obliged.
Iman data date to?
29. Highly obliged.
Your lordship, I beg to mention item number 38. Lordship, the accused is on interim. May the interim continue. The charge is filed within 1 week.
I'm not getting you. 38.
Yes, your lordship.
When do you want?
After within 1 week.
The prayer of learned counsel.
Charge sheet has been filed.
Okay. Submitted the charge sheet has been filed by CS number so and so.
2026, dated 31/03/2026.
So what do you want?
Within 1 week, the date, and the accused will, it may continue, interim may continue.
All right, hence call for the TCR. Interim order passed earlier to continue. Please the matter again on 1 week.
Highly obliged. Yeah, please, your Lordship. Lordship, it's an NDPS case in charge sheeted matter, Lordship. The TCR may be called for.
All right. You submitted that the charge sheet has been submitted in this case. You have the number? Number is there. Charge sheet number.
Charge sheet number.
You have annexed
No, I have not annexed a charge sheet. I have the certificate.
the number.
Charge sheet number. CS number.
For probably lots of CS is.
Lordship,
not
there is
part-
it is the NDPS case number is there. The NDPS case number is, I have it mentioned in my
And
petition.
call for the scan copy of the NDPS case number
17/2026.
along with CD. Please again on.
Fabian law.
Yes, next.
Number 2. Number 2.
Call for the, it is solicited. Huh? Right, CD.
Five.
Item number 3.
May I please, Lordship, charge matter, POCSO is there, maybe TCR will maybe call for.
Learned counsel for the petitioner. It is submitted that charge sheet has already been submitted, hence call for the scan copy of the TCR in POCSO case number
147/2025.
from the special judge POCSO Morigaon
Yes.
along with the CD. Also issue notice to the respondent number 2, steps by speed post AD within 3 days.
6 minutes.
Must.
Item number 4.
May I please, your Lordship, this is a regular bail. Petitioner is in jail, 7/11/2025, Lordship. Petitioner already got bail on 16, Lordship, 16/5/2025 and submitted the bail on 17/5/25. And next date is fixed in 28/5/2025. But due to lack of knowledge and communications gap to the council, he did not appear before the trial court, Lordship. That's why NVW was issued, and 7/11/2025 again he was arrested. Right now he is in jail 5 months, 15 days, Lordship. So he want to cooperate and he appear each and every date, Lordship, on the trial, Lordship. So kindly allow me to release a bail, Lordship. FIR in page number, Lordship, 3. May I read, Lordship? Already evidence is collected. Case already committed, Lordship. Charge sheet was filed, Lordship. Investigation was completed, Lordship.
Trial court is not confident that you will appear.
Right, order dated 9.
It is the stage of PNA.
I already
Yes.
2 times rejected, hence I am appear before this
Call
honorable
for
court.
the TCR at this stage. Or counsel for the petitioner. Call for the scan copy of the TCR. Please take it note.
7-5.
Much obliged.
Item number 5.
May it please your lordship, NDPS commercial quantity lodged.
All right.
CD may be called for.
CD.
Like, on 22C, অলপ দীঘলীয়া date দিয়ক, অলপ দীঘল date। 114,
12. 10,000. Item number 6.
My lord, PRS bail application, your lordship will find the FIR page 9, my lord. Page 9, my lord. And on plain reading of the FIR, my lord, that is, yes, there is a revealed that is a attempt. But this FIR was lodged after 5 days of the occurrence. And continuous from 11.13, dear lordship, kindly see. She is a temporary employee and she is going to be terminated after 6 months. So, delay of 5 days, that is also not explained anywhere, my lord. I am the administrator of the, my lord, that institution, my lord.
Well, at this stage, we can only call for the CD.
My lord.
Yes, heard Mr. T.J. Mohan to learn it senior counsel and learn it additional PP. Call for the CD, release the matter again on
13 May.
Develop.
Item 7.
Election order of that, my lord.
Yeah.
Yeah, for the petitioner.
Yes, lordship.
There was a prayer made by learned senior counsel for the opposite side for an adjournment.
Lordship. Lordship, only the interim may continue, lordship.
All right.
Good.
Heard learned counsel for the petitioner on the prayer of Mr. R.P. Sharma, learned senior counsel for the respondent number 2. Place the matter again on. Give a date. Interim order passed earlier to continue till the next date of listing.
10 May.
Lordship, can it be after 15th, lordship? 18th? 18th.
Item number 8.
State, my lord.
So appeals for the state respondent.
Lordship, the interim has been.
Item number 8.
May I please your lordship. Lordship, the respondent side has already filed their affidavit in opposition, my lord. There is an interim order, my lord, dated 24/1/2025. The husband has filed this transfer petition, my lord, basically on the health ground, health issues, my lord.
Wish for the respondent, D.K. Borderloy. Our learned counsel for the petitioner, none appears for respondent number 2. Place the matter again on. Not to run, none appears for the respondent. Place the matter again on. So and so interim order passed earlier. Shall continue till the next date of listing.
Obliged, lordship.
5 May.
Item number 9.
May it be lost.
Your lordship, I'm appearing for the respondent side. We have already filed our affidavit. So lordship, can the matter be adjourned for the day because engaged counsel has gone to Netralaya for his mother's eye operation?
My lord, whenever it comes the major, they have already submitted. Respondent has submitted objection that the other day I have received it, my lord. And today the same thing they are happening. Your lordship will be remembering whenever the matter appears in the list and they make a mention in this and that day, my lord.
I don't have such a memory to remember every case. And there is an order admitting the matter for hearing.
Yes, sir.
Has it come up in the admission again? 4/2/26 matter is admitted for hearing.
Yes, ma'am. It is your lordship's order, my lord. Your lordship's order for.
Yes, so it should come up for hearing. It has come up in the admission column.
Your lordship may take it for hearing today, even if it is in the admission or a short date, my lord, for in the hearing.
All right, the matter is longly listed in the admission column since there is an order to list the matter for hearing. Further, learned counsel for
27th.
the respondent has prayed for adjournment on medical ground of learned engaged counsel. Hence, list the matter for hearing give a hearing date.
12 May.
Yes.
On 12 May. 12 May. It is.
Yes, next.
No.
May I please, your lordship, this is a criminal revision petition. We are challenging the interim order, lordship, maintenance order, lordship, which was passed by the principal judge family court Porpeta, lordship. In this matter, lordship, opposite party, Afuja, maybe he is married to another person, but still this is not officially verified. So we need to time, lordship, to verify whether opposite party is married or not, lordship.
All right. Learned counsel for the petitioner, it is submitted that some time is required to verify the information that the opposite party has remarried. Hence, list the matter again on.
Next date, lordship, next date fix on 16, lordship, maybe NBW was issued, lordship, that it will issue,
So
lordship.
tell us when you need it.
Date may be fixed, lordship.
Huh?
I need to, date may be fixed, lordship.
That is what we are saying. Give the date.
16, lordship, 16/5/2025, lordship. Much obliged. Obliged.
May I please, your lordship? Lord, this is an appeal against acquittal, my lord. And my lord, there was a delay, my lord, the IA was disposed of, and other side, my lord, the respondent, they were appearing and filed their objection in IA. And
IA
today,
is for condonation of delay.
yes. That
Disposed
was
of.
disposed.
So no other IA is pending now.
No,
The matter is ready for hearing.
yes.
Is submitted by learned counsel for appellant that the matter is now ready for hearing. PCR is here.
No, my lord, TCR may call
Let's
for.
call for the PCR and list the matter again on. So it's for orders.
13 May.
Obligement.
Item number 12.
May I please, your lordship? This revision is against an order of maintenance, my lord. Lordship, will just take you to page 24.
Yes.
Now, page 24, paragraph 2, my lord. That she was married with the opposite party on 4/6/2017 according to Islamic rites and rituals, and since they are living together as husband and wife in a rented house at Maligaon, as because the relationship was not accepted by the parents of the opposite party. So, my lord, the case of the wife is that they were married as per Islamic rites and customs, on 4/6/2017. Now, lordship will see. I'll just take you to the cross examination which your lordship filed at page 40.
Yes.
So what shall I state shall be the truth and nothing but the truth. I was staying at Maligaon BCC colony, and after having married with the opposite party, I was taken by the opposite party forcefully and started living as husband and wife at a rented house, but no social marriage was solemnized, but we are living as husband and wife. I cannot remember the date as to when I was taken away by the opposite party. Now, lordship will just come down a few lines. I have filed a divorce case. Lordship has found me, right? After around 7 lines below the opposite party, my lord. I have filed a divorce case in connivance with the present opposite party, but divorce was effected only after I entered into marriage. What had happened, my lord? She was already married to a person. There was no connection, my lord. In the case, he says that she was married on 6/4/2017. The divorce was effected in 2018, my lord. On the basis of this, my lord, the impugn order was passed. Holding that, my lord, the lordship will find the impugn order at page 75. Absolutely no connection. It is in her cross, she says that she was never married. In the petition, she says she was married. And in fact, my lord, even the second marriage is otherwise. The divorce was effected at a much later date.
Yes, where is the impugn order?
At page 75, my lord. It starts at page 76. May I read, my lord? Page 76.
Yes.
Now, my lord, the case of the petition filed under so-and-so, praying for monthly maintenance for herself and her minor child from the opposite party is that on 4/6/2017, their marriage was solemnly as per Muslim rites and caste rituals, and they started to live together as husband and wife in a rented house at Maligaon. That having learned about her pregnancy, the opposite party started to inflict torture on her, forcing her to go for abortion. The opposite party was also neglecting her to provide medical treatment, necessary checkups. So she filed an FIR with the Jalukbari police station, which is registered so-and-so, and left the house of the opposite party. Now, she left the house of the opposite party. Lordship will see. The opposite party is running a hardware shop named Nehal Store at Sundarguri, and his monthly income is not less than 60,000. The case of the opposite party in his written statement is that the petitioner was a regular customer in his shop, and as the petitioner is a regular customer, so he sold goods to the petitioner on credit. And when he asked for his due against her purchase of so-and-so, she refused to clear the outstanding amount to him. And finally, on 26/2022, the petitioner lodged an FIR against him, showing him as her husband with the allegation that she was tortured by him. He had approached him before the Honorable High Court, Gauhati High Court, and prayed for anticipated bail, and the interim prayer for arrest PS bail was allowed. And on a later date, the Honorable Gauhati High Court made absolute his interim prayer for a PS bail. In his written statement, he also stated that as per statement in her petition, her marriage was solemnized with was solemnized on 4/6/2017, whereas the decree of mutual divorce petition with her former husband was disposed of by this court on 21/10/2018. So she was, my lord, already married at that point of time on the LS date, my lord. Now, I'll skip the paragraph 5, my lord. Before this court, the petitioner has examined herself as PW1, wherein she reports the facts stated in her petition along with the facts that in the Matri Aru Shiksha Surakha card, Exhibit 1, issued by the Ministry of Health and Family Welfare, the opposite party was shown as the father of her child, and in the and also in the birth certificate. Well, this was not within our knowledge at that point of time. In a cross-examination, she has categorically stated that there was no social marriage between the opposite party and her husband, and they lived together as husband and wife, that the name of her former husband was Sanatan Biswas and was as a drug addicted, and he had filed a divorce case in connivance with the opposite party, but the divorce was effected only after she entered into the marriage with the opposite party in the year 2017. Now, PWJ Anand Prakash Dixit has stated before this court that the petitioner and the opposite party had been living as husband and wife in a rented house since 2017, and their conjugal life was happy for 4 years. And thereafter, the opposite party started to torture the petitioner both mentally and physically to get the pregnancy of the petitioner aborted. In his cross-examination, he made it clear that in the month of May 2017, the parties entered into his rented house, and at that time, the petitioner had a baby. That after the birth of the second child of the petitioner, he came to know that there was no marriage between the petitioner and the opposite party. DW1, Julfi Ali stated that the petitioner was living with her husband and her child at BBC Colony, and her husband divorced her by a decree passed by this court on 31/11/2018. Arifa Begum speaks in the same way that the statement given by the DW1. DW3, opposite party has reproduced the fact that in his written statement, along with the facts that in the petition, though his marriage with the petitioner was solemnized, was
All right, Mr. Dev, we can't go for final hearing today.
Lordship.
Too many items.
I can understand, my lord.
Too many bail hearings are there.
Opposite party. Now the thing is that, my lord, there is a domestic arrangement and they are living as husband and wife from 2017. There is evidence. And he has not filed any suit in civil court for declaration of nullity or something. Now in such circumstances, my lord, the court has awarded maintenance. Now not a single pie has been paid till today. So my instruction, my lord, he should maintain the opposite party and the children. He is also having one son, my lord.
Is there any stay order?
No, my lord, in fact, there was no stay order, my lord, after appearance of the opposite party, my lord, that was the order, my lord. That was why I was reading out the.
On the date of judgment, my lord, nothing has been paid. So the purpose of section 125 is to prevent vagrancy and destitute, my lord. Destitute of a woman, my lord. That thing, your lordship will, before, my lord, passing any order, lordship will direct for some.
Okay, since you have appeared, we'll fix a date for final hearing now. I'll learn counsel for the petitioner and learned counsel appearing for the sole respondent. You have filed any objection? No.
My objection.
The matter is ready for hearing, hence. Any record is required?
Required, my lord, otherwise.
Everything is annexed.
Not annexed, my lord, but
Maybe call for, my lord.
because the assets and liabilities, those things are there, my lord.
I think it is annexed, I think. Just now, so.
Is well, the ENF, my lord.
Huh?
The documents have not been annexed, the documents annexed to the assets, my lord, affidavits are not annexed, my lord. Otherwise, it is annexed. At page, my lord,
Hence, call for the scan.
58.
Hence, call for the matter is disposed of.
disposed of.
Call for the TCR. Place the matter again on. Wait on a hearing day. So that if the TCR is received, we can go in for a.
Last week of May, my lord, any day.
26 May.
Oblige me.
May it please your lordship. They're very used
What
by.
is all this?
Please, your lordship, the copy which has been served upon us, a lot of pages are there which are not distinct. Like page number, volume 2, page 276, 277, 278, 279, 283, 284, 285, 286, and
What is
248.
the matter about?
Yes, your lordship.
No, your lordship,
Your
it is in volume 3.
If he will give me the list, then I
I'll
can
give,
provide it.
I'll give the
Definitely,
list.
definitely.
I will
I
give
have
the
a
list.
humble prayer, your lordship. Actually, your lordship, this matter is arising out of a DV case number 08 of 2024. And your lordship, presently there is 3 already criminal revision is pending, which were arising out of the same DV case between the same parties. So my humble prayer before your lordship is that if all these matters tagged together, then it will be helpful for the litigant also before the honorable court also, your lordship. And your lordship, there is another IA criminal, your lordship, 165 of 2026, which was also disposed of by this honorable court where 53 days delay was there. And in respect of listing a criminal revision petition, which is still pending to number. So my humble prayer, if for this matter tagged together, then it will be easier for the other litigant also for us also. I will.
No objections regarding.
But heard learned counsel for the petitioner.
I will provide it. Give me the list.
Learned counsel for the respondent, it is submitted that the matter may be listed with the other connected matters. That is,
He will-
give the list of the numbers.
Yes, your lordship.
It is also submitted by learned counsel for the respondent that some of the copies of the documents submitted furnished are not legible. Hence, petitioner is directed to furnish legible copies of the said documents. List these matters again on your date.
13 May. Oblige.
From the.
Okay, given agreed date.
7th of May, your lordship.
It depends upon them, when the copies are going to be provided, then only we are going to
We
file.
provide it because 7th of May. Ase homework.
All right, 7th of May is sometime away. By that time, I think
Yes.
they can provide.
Then the question of preparing objection, it's a voluminous thing. 3 volumes, I require time to go through those documents.
No,
are
when do you want? So give us a date.
3 weeks time.
No, your lordship, because this matter is
Your
pending.
lordship.
Your
It's
lordship.
pending, no doubt, but that is 2 orders, that is appeals are there. 513 and 520.
7th of May is already 17 days, almost 15 days.
From the same order, husband and wife have filed a appeal, a revision. I have also filed a revision that is numbered as 530, and this one is 520. Records have already been called for. Low court.
We have the case.
14th of May.
Oblige, lordship.
14, your lordship, from 12th till 18, I'll be out.
19.
19. Oblige.
It is about 14.
Criminal petitions, other side has appeared against a domestic violence case issuing of summons. I think he's senior in some other court. So, my lord, let it come in the next week, my lord, fixing a date.
Lordship, senior was engaged in court, so the last instruction I received was to let the matter reach. So, Your Honor, one
We don't, no, we can't keep going back now. Okay, heard Mr. Figure Chaudhary Learned, senior learned counsel for the petitioner and learned counsel appearing for the respondent. Give an agreed date. Then.
Any day, my lord.
28, Lordship.
Place the matter again on 28.
Not 29, 28, my lord, something, 29. 29 for.
Yes,
No, interim order to continue.
interim order passed out to continue till the next day of listing.
Mate, Mr. Roshi, my lord. My lord, here, my lord, we have challenged the FIR, my lord, which is on the basis of the departmental inquiry report. Now, by the last order, the respondent was directed to file their affidavit, counter affidavit, my lord. And Mr. P.N. Goswami appeared for PH department. My lord, 5/3/2026 order, my lord. Opposite party 90, আছে নেই? এটা next week. Good.
My lord, since opposite party is not here today, I will inform my lord them, my lord. Lordship may fix in the next week, my lord, or on sixth, my lord, 6th/5.
Learned counsel for the petitioner. None appears for the respondents.
Yes.
List the matter again on 6/5.
6/5, my lord. Obliged.
Bail hearing B, item number 17.
The lordship may see the last order 6/4, my lord. This search the bail, my lord. After that case record, after this status was called for. My instruction on 7/4, nothing was happened, my lord. On 29/4, the next day they speak for, my lord,
Next.
evidence, 29/4. Maybe fix after 29/4.
It is heard learned counsel for the petitioner and learned your amicus appearing for respondent number 2. Also heard learned additional PP. It is submitted that the next date in the trial is fixed on 29/4.
29/4.
Hence list the matter again on May
May
4th, 5th, May,
4. My lord.
6th May.
Obliged.
Deeply
6th of May.
obliged. 6th of May.
6th. Obliged.
Deeply obliged.
Item number 18.
May it be the lordship, my lord.
Lordship, CD was called for along with the status report, and that is not, that is awaited, Lordship.
That time. That much I cannot be there.
And please.
Okay, elections and all, yes.
My lord, I understand.
CD has not been received. Learned additional PP will issue reminder to the IO to produce the CD on the next date without fail. Please the matter again on
7/5.
6.
Item number 19.
My lord, not 7/5. 7, I will not be there from 7, my lord.
10th.
10th, my lord. maybe.
10.
10th May is Sunday, 11th May. 11th May.
Lordship, item number 19 may be taken up after sometime scenario is on leg at another.
19.
Lordship.
Item number 19.
19.
Time being.
Time. Twenty-one.
Been filed, Lordship.
This is NDPS.
NDPS. Yes, Lordship.
Already submitted that CS has been submitted, right? Charge sheet number.
Ship 19/2026, dated 20/04/2026.
Call for the scanned copy of the TCR along with CD list again on
7th May.
7th May.
Obliged. Item number 27.
May it please the lordship.
Yes, respondent number 2.
Well, they have appeared, my lord.
Yes. Yes.
My learned friend Arboro has gone through the case diary. So can it be just after some time? Or do we know sign? Do we summon
My lord, on the statement only, the girl statement will do, my lord, possibly because the boy is 20 years and the girl is 17.5 years, my lord. So, my lord, everything will rest upon the statement, my lord. As per my instruction, there is a love affair between both of them. Then, my lord, the affair has been lost. Page 8 is the affair.
The only issue is the victim is a minor at that relevant point of time.
Yes, yes, yes.
I can. And my lord, page 8 is the FIR, my lord. Victim is alleged to be 17 years, but she is almost 18, my lord. And the boy is 20 years. There is a love affair, my lord. Between them, my lord, and boy is behind the bars for almost 56 days today.
Yes, Mr. Borwa.
Medical report is yet to collect, my lord. Otherwise, my lord, 183 statement, my lord. She has stated, my lord, that she had love affairs, my lord, and my lord, they involved in, my lord, physical, my lord, then she become pregnant, my lord. Then, my lord, both the parents, both the family members were informed. And, my lord, they wanted to take the victim girl, my lord, but the mother of the victim girl not agreed to, my lord, let her go, my lord. Then, my lord, this affair was lost, my lord. And her age is, my lord, around 17 years, my lord. This is our 183 statement. Her age is the factor, my lord.
A certificate is there.
It is there. Birth certificate.
Boy is behind the bars for 56 days, lordship.
It is a 90 days offense.
Lordship, but my lord, it's a 90 days offense, but my lord, he is also, my lord, 20 years old, my lord.
Yes, counsel for
The victim girl was 17 years old at that relevant point of time, and I think investigation has not yet been complete. Pregnant.
Ossification test doesn't. Ossification.
I think it is only pending for medical report.
Otherwise, my lord, the her 183 is not against the accused person, my lord, but considering her age, my lord. Because she is below 18 years.
Basically, it's a case of adolescent love. So
Yes, sir.
heard Mr. Learned counsel for the petitioner. Learned additional PP. Also heard learned counsel, Mr. So appearing for the respondent number 2, informant. Error, this is an application under so. The brief facts of the case are that the yes, the FIR is that the petitioner along with 2 other persons tried to practice Not try to practice. You were running the tuition class. Who is running the tuition class? The beauty Saikya?
Lordship.
Mother of the accused.
Mother of the accused. All right, you consult the case of as per the FIR, the victim who is aged about 17 years used to attend tuition classes with the where the teacher at the residence of the mother of the present petitioner. And there and at that place, the present petitioner induced the victim to enter into a relationship with the petitioner, as a result of which she became pregnant, whereas the CD as called for has been received. And the statement of the victim girl recorded under section 183 BNSS before the magistrate indicates that the victim, who was aged about 17 years, was in a love relationship with the petitioner, who is aged about 22 years. And in course of such relationship, they established physical relationship leading to pregnancy of the victim. Full stop. The investigation of the case appears to be almost complete and is pending for the medical report. And meanwhile, the petitioner has spent 53 days behind bars. Full stop. In regard to the facts and circumstances of the present case, it appears that further detention of the petitioner may not be warranted. Accordingly, prayer for bail is allowed. The petitioner so and so shall be released on bail of rupees 50,000 with 2 securities of like amount to the satisfaction of the learned special court.
POCSO Kamrup Metro. I'm obliged, madam.
Special just POCSO Kamrup Metro.
I'm obliged, madam.
Further provided that the petitioner shall not attempt to influence the witnesses in any manner. Petition stands disposed of.
Obliged.
Accordingly, don't beg this.
Finding item 19.
It is a lot. But Lordship will find the FIR at page number 12. Page number 12. But basically, the allegation in the FIR is that, my lord, while the petitioner, my lord, was coming on train, my lord, as a passenger, my lord, he was stopped, he was searched, my lord, and from his bag, my lord, around 26 kg of ganja was allegedly seized, my lord. Now, the police, my lord, filed charge sheet under section 20 small b 2c of the NDPS Act. Perhaps, my lord, charges have already been framed, my lord, and the petitioner has completed 126 days. My lord, the two grounds, my lord, for moving this bail application are, my lord. The first ground is that, my lord, non-compliance of section 48, my lord. There is a, my lord, entry, the WT message, my lord, which was apparently to be sent to the father of the petitioner, my lord. But to our knowledge, my lord, that information was never submitted to the father, my lord. We never knew about the pendency of this case, my lord. That is the first ground, my lord. That information may be there in the record also, my lord, that whether, my lord, the information pertaining to this matter was supplied to the family members of the petitioner or not. There is a WT message also, my lord.
Yes, Mr. Borwa, anything other than this WT message?
My lord, DCR of the my lord, of the case, my lord. As per 35 and 47, my lord, these are complied with, my lord. 14 notice, my lord, I have not found, my lord. So that may be, my lord, that query that may be confirmed, my lord, whether 14 notice was served or how it was served, my lord. That instruction may be obtained from the, my lord, trial court, my lord. So 37, 35 and 47 are complied with, my lord.
Well, the WT message is there, man. I have a certified copy. Your lordship wants to peruse, man, I can furnish the certificate.
No, it is here.
Yes.
No, beyond the record, what instruction will you get?
Question is that, my lord, you 14 notice, my lord, whether it was served or not, my lord. Because that will be clear from the, my lord, original case diary, my lord. The question is that, my lord, if it is not served, my lord, how the prejudice has been caused to him, my lord? Because whether when he was produced before the trial court, my lord, on the day or of his
CD is
arrest,
not
my lord,
here.
whether, my lord, he has put all this ground or not, my lord.
CD is not here.
My lord, entire case there is only the part of the case there is there.
Well, the question of prejudice, my lord, can be answered this way, my lord, that the day, my lord, when he was produced, that day perhaps no bail petition was filed on behalf of the accused, my lord.
When was he arrested?
He was arrested, my lord, on 17/12.
17/12, he was produced before.
Yes.
17/12, he was for FIR is on 16/12, my lord. He was arrested on 16/12. Page number 14, my lord.
But the order sheet does not contain the production order.
What's that?
Just a moment. 112. Must be there. 17/12, yes. No, it must still be that they were served with the notice, but they may not have chosen to engage counsel on that day. It is not the job of the prosecution to ensure that legal aid was provided.
But on that particular day, my lord, their guardians were not informed. They had no knowledge, my lord, regarding this pendency. That is why, my lord, no bail petition could be filed for perhaps, my lord, on behalf of the petitioner.
Does not follow. Even if they were informed, it is possible that no bail petition is filed.
Yes, that, my lord, information perhaps, my lord, be pertinent.
All right, let's have the
Yes,
CD done.
yeah. Then my second ground,
Next week.
Second ground, lordship may hear, my lord. My second ground is the non-compliance of section 50 NDPS, my lord. When a person is searched, my lord, definitely, my lord, he will have to be given an option whether he may be searched in the presence of a gazetted
What is
officer
the
or a
recovery?
magistrate.
It is recovered from the
Now, lordship will
train,
kind.
my lord, Rajdhani Express, my lord. And, my lord,
Was it recovered from his body? What 25 kg of ganja?
Yes, lordship will kindly see. No, Lord, no, that is not the thing, my lord. Lordship will kindly see that 50 notice, my lord. They have annexed the notice that was given to him. Lordship will kindly see section 50 notice.
If the recovery is not from the body,
My lord, if the search is same, regarding the body as well as the bag, then 50 will come. If there is only one search.
No, if
separate-
no recovery is made from the body, then no
body
question of
recover-
section
mo-
50.
No, body was searched, my lord.
Let
Mobile
it be
phone was-
searched if nothing was recovered, if
No,
the
mobile phone
recovery was from the body.
No, mobile phone was recovered, my lord. Mobile phone was recovered from
We're
his
not
body.
on mobile phone,
But
we
he
are
was
on the
searched, my lord.
drugs.
No, he was searched.
Hmm.
The search is same, my lord. That
Which
is
law
that-
requires that section 50 notice is to be issued for recovery of mobile phone?
No, the
That-
search is important, my lord. If when a search is done
Yes.
on the body as well as the bag, my lord,
Yes.
then 50 compliance is required, my lord. That is what has been laid in the Supreme Court judgments, my lord. There are several judgments on this, my lord. Now the thing
I've
is
yet
that
to come across any.
I'll place, my lord.
Yes.
Now the thing is that lordship will kindly see the section 50 notice, my lord. When, my lord, an option is given, whether he wants to get himself searched before a magistrate or a gazette officer, my lord, the reply must be in the writing. It must be in the writing.
No, all that we can go into only when we are satisfied that the 50 notice is relevant when recovery is made elsewhere.
Yes.
Other than the body. Yes, para.
Para 65, my lord. The summary. 66 is the summary, man. Lordship may also see the final analysis, my lord, at para number 121, final analysis. The only idea which we have referred to the various decisions of this court, starting with Balbir Singh till Dayalu Kashyap, is to highlight that section 50 of the NDPS Act has been tried to be interpreted and understood in many ways. As noted earlier, in some of the decisions of this court, the concept of inextricably linked to person was applied. In other words, if the bag, etc., is in immediate possession of the accused and the search is undertaken of such bag, even then, according to those decisions, section 50 would be applicable. It could legitimately be argued that the interpretation of section 50 restricting its scope only to the search of a person of the accused would frustrate the object as the apprehension of the person concerned may continue to subsist, that he may still be implicated by the police or any other person for more stringent punishment of carrying commercial quantity by getting rid of the rigor of the mandatory provision of section 50 by implanting the contraband in a vehicle, bag, etc., accompanying the person. what we are trying to convey has been explained in the case of state versus claim in so and so. In the said case, the issue before the US court was, therefore, in the said case, the object which is a person was carrying was held to be part of his body. A similar view could also have been adopted while interpreting the term personal search. However, in view of the plain and unambiguous statutory provision, there is no scope of interpreting 50 in any other manner than the interpretation explained in Baldev Singh and Pawan Kumar.
So this goes against you. It says there is no scope of interpreting section 50 in any other manner than the interpretation explained in Baldev Singh.
Baldev Singh, madam.
Baldev Singh says what?
Baldev Singh has been discussed above, my lord, in the.
Only confined to the person, body.
I'm coming to that.
Para 76, a bare reading of section 50 shows that it only applies in case of personal search of a person. It does not extend to the search of a vehicle or a container or a bag or premises. See State of Punjab versus Baldev Singh. So anyway, let's have the CD.
My lord.
Nepal, my lord. So it is, my lord, apart from, my lord, sending it through WT message, my lord, there is no other manner but through which, my lord, 14 notice would be served, my lord.
Let me retain this copy of the judgment.
My lord.
We'll go through. Had learned counsel for the petition and learned additional PP. It appears upon a perusal of the TCR that the CD would be required to ascertain whether the notice under section 48 was served upon the notices. Hence, call for the CD and list the matter again on. So and so. Judgment to rakhi diyo. September 3.
Second week of May, man. Okay. Second. Date.
It Saturday no.
Highly
19.
I'm sorry, my lord. Lordship, item number 25, Lordship, that was take with item number 22 to 25, Lordship. Lordship, default counsel may be mentioned all the items, Lordship, but in 25, Lordship, we have submission, Lordship. Other accused, Lordship, they are on bail, Lordship. And the petitioner, only the person, he is not on interim, Lordship. Lordship can be maybe hard, Lordship, this matter.
The CD is already there, my lord, so that is why we have fixed it on the next week, my lord.
Lordship, 60 days offense, Lordship, 2 days, 45 days. Other petitioner, they are on interim, Lordship, without case diary, Lordship, and they already enlarged on bail, Lordship. When they were in custody.
You are in
11
jail.
days. Yes, Lordship. Lordship,
So?
they enlarged on bail when they were in custody for 11 days, Lordship. Same
Anyway,
affair,
cases
Lordship.
have gone now. We can't call them back.
Lordship, we
Where
have.
were you sleeping? You said you've been here.
Lordship, in the morning, someone maybe mentioned, Lordship. Lordship, kindly be heard, Lordship, after.
We are now on item.
Lordship, we are sitting here, Lordship, but it's not called for, Lordship.
When have we fixed it? When is it fixed?
Item number 25.
8th of May.
Oh,
8th of
Lordship, our statutory period will be exceeded, Lordship.
Fixed perhaps.
Lordship, other all petitioner, accused, Lordship, they are on bail, Lordship. Kindly, Lordship.
Next week.
item number 26 of Saudi.
25.
26.
Appropriate bench. 8-5 question. 8-5. 8-5.
2 to 5.
গোটেইকেইটা একেলগে আছে।
2 to 2.
এজনৰ হোৱা নাই দাদা। কোন পাৰিতে?
এই হলে আজি হল 20, 30, 22nd. 16 days. Statutory period over. Oh,
And for item number 25.
next week or DD paper তেতিয়াহলে।
Lordship, I'm behind the bar for 45 days, Lordship.
There must be a reason you were not granted interim bail.
Lordship, we could not submit well, the thing.
Yes. Huh? The next week here will be May 45. Restoring deliverable 30th, please. 29, 30, 30. Similar. 30th.
30th. Yes, Lordship.
May I please, your Lordship? 483 bail application, Lordship. Lordship, the present petitioner has been arrested from the railway station. The suspected contraband ganja has been recovered and registered under intermediate quantity, Lordship. Thereafter, the search sheet was laid and LCR was called for, Lordship. And the petitioner has been behind the bar for last 68 days, Lordship. Lordship, the main ground which we have taken in this through this petition, Lordship. I have also filed an additional affidavit. Lordship may come to the FIR, which is on page 17, Lordship. The accused, as part the petitioner, as part the FIR, was taken into custody on 13/2/2026 on 11:20 PM, Lordship. Thereafter, Lordship, the seizure of the contraband was made, which the seizure list on page 22, Lordship. It was made on 14/2/26 on 2:30 AM, Lordship. Thereafter, Lordship, on if Lordship comes. Lordship, the physical custody was taken on 13/2/26 on 11:20 AM, Lordship, as per the FIR. Lordship, then the seizure was made on 14/2/26 on 2:30 AM, as per the seizure list, which is on page 22. Lordship, on thereafter, Lordship, as shown on forwarding, he was arrested on 14/2/26 after keeping him whole day at custody on 8 PM, Lordship. Thereafter, on the next day, Lordship,
Arrested when?
Lordship,
Shown arrested?
he was shown to be arrested on 14/2/26 at 8 PM, Lordship. Lordship will find that on forwarding, Lordship, on page 24, Lordship. And Lordship, on after keeping the whole day, Lordship, that on next day, Lordship, after 1 PM on 15/2/26, he was produced before the ministerial court, Lordship. Lordship, here I am preying on illegal detention, Lordship, relying on one of the Supreme Court's judgment, Lordship, and coordinate bench order, where, Lordship, the physical custody, if the physical custody of the accused is taken into consideration, and if it goes beyond the 24-hour, the Supreme Court is also clear, and the coordinate bench order reflects the Supreme Court's order, Lordship.
Yes, PP.
From the FIR, my lord, page number 17, my lord. The person was, my lord, intercepted on 13/2/2026 at 10 PM, my lord.
13/2/2026.
Yes, night.
Then, my lord, GD entry was made by thereafter, my lord, 11:20 PM, my lord.
Yes, that is what I have stated.
11:20 PM, my lord, GD entry was made, and thereafter, my lord, the search was made, my lord, as per the CZR is on 14/2/2026, 2:30 AM. That means, my lord, 13 and my lord, between 14, my lord. Midnight of
Production,
13.
when was the production?
My lord, on as part of my lord, forwarding report, my lord, page
15.
24. He was produced on, my lord, 14, he was shown to be arrested on 14/2/2026 at 8 PM, my lord.
And produced?
And forwarded on 15/2/2026.
After 1 PM, Lordship. After keeping him whole day on the custody, and that is a clear violation of Article 22, Lordship, as stated in the Supreme Court judgment, Lordship. Subhash Sharma versus Directorate of Enforcement, and one of the same view held by the coordinate bench of Honorable Gauhati High Court, Lordship. Physical custody has to be taken into consideration. Upon such violation, the arrest is considered to be illegal, Lordship.
You say 10:30, you say 11:20
No,
PM.
They,
13/2/26. Huh?
10 PM information received, my lord.
Information received.
Information received, my lord.
When
From
was he
10%.
apprehended? The,
physical custody on 11:20 PM.
where from do you get it?
Lordship, on FIR, Lordship, page 17, Lordship. If I may read, Lordship. With reference to the subject cited above, I have the honor to report that on 13/2/26 at 11 PM, ASI so-and-so of Kamakya GRPS OP, who was along with so-and-so on platform patrolling duty at Kamakya railway station, reported through a phone call to the OC of Gauhati GRPS White, above noted GD reference that on same day at around 11:20 PM, during the course of checking passengers' luggage, platform number 1 at Kamakya railway station, they recovered 11 packet wrapped with brown color plastic, suspected to be cannabis.
Produced on 15/2/26 at 1 PM.
15/2/26. In the forwarding, Lordship, it is reflected, the date is reflected, but in the production order also the time is not there, but I was there, Lordship, when it was produced, Lordship. It is my statement, Lordship, after 1 PM, Lordship. He has to be produced on 14. If he was produced on 14, after keeping him whole day, Lordship, he was arrested on 13.
He cannot produce on 14 at midnight, my lord. If the
No, not
24 hours is, my lord, taken into consideration, my lord.
Not on midnight.
Because on 11, my lord.
No, he was apprehended on the night of 13th itself.
Yes.
So whole day 14th was there.
Yes.
Why should you wait till midnight?
NDPS, my lord, it takes some time, my lord, to make the other formalities, my lord.
So we
That
cannot.
is why, my lord, like other cases, my lord, the accused person cannot be, my lord, immediately forwarded to the police.
Even by 6 PM, 7 PM, you could have produced. At any rate, before 11:20 PM, duty magistrate is there.
Yes, Lord. And it cannot go beyond 24-hour, Lordship.
Been shown as 14/2/2026 at 8 PM, my lord.
That has been discussed in the
Page
Supreme
number
Court
24.
order.
That doesn't matter. You can show any time to make up for the lapse. That doesn't matter. That is what we have been telling all the time.
Condition may be
So, my
imposed,
lord,
Lordship.
if Lordship allow in his application, my lord, there must be some strict conditions.
Right, we'll put conditions is next.
Deeply obliged.
29.
May I please, your lordship? Lordship, the matter relates to POSCO Act. As per the office note dated 24/2026, lordship, scan copy of the TCR has been received and the report has not been received by the registry, but there is a flag mark F of the postal receipt, which indicates that in the last page that it has been delivered to the addressee. Flag
X.
A. Flag A.
This is what POXO.
Yes, lordship.
Alright, heard learned counsel for the petitioner and learned additional PP. Scan copy of TCR has been received. As per consignment stroke MO tracking report at flag A. Notice has been delivered to the respondent number 2 on 13/4/26. But none appears for the respondent number 2. Hence, so and so is appointed as amicus to represent. Anybody is present, amicus? You are there. Already proceed. Extra copy be served upon the newly appointed amicus. Place the matter again on.
Short date may be given, he is behind 21/6, short date may be given, he is behind 21/6/25.
First week of May. 6 May.
6 May. God bless you.
Item number 30.
You mentioned Kona Asil.
Lordship,
Yes, what is your instruction?
we'll approach the trial court, Lordship.
Huh?
We'll approach the trial court.
It is submitted, the charge sheet has already been filed by CS number. So and so, if the charge sheet is submitted in this case. Learned counsel for the petitioner submits that the petitioner shall approach the learned trial court with appropriate application. Accordingly, the present application stands closed.
Number is 25/2026, dated 29/03/2026.
Closed. This
33.
Hey, please, your lordship. CD was called for upset schedule. It is not available.
Red CD is not available. Place the matter again on so and so interim order passed earlier to continue till the next date.
Obligation.
35/36.
CD was called for. Double lordship. The second time, your lordship.
Alright, CD not available. List again on so and so interim order passed earlier to continue till next date.
After fourth of. Okay, then lordship on 7th, 7 May.
Yes.
7 May.
I am for the only 35.
7th of May, lord.
35 and 36, yes.
I am for the 35, lordship. 36 also same FIR. Master place.
37.
Receive.
37.
Item number 36. Thirty-seven, 36. 36, I can 7 May. 7 May.
Your lordship,
This for 36 lots.
I am for item number, interim may be continued.
Yes, it is interim is continued.
Thank you.
36, 37 or interim is already 30, 36, interim is continue. None appears. CD Received. CD is received. List again on next week in detail. Next week,
Then we have to retain the city lot.
CD be retained.
Four, 5.
Item number 40.
May I please, your lordship? 483.
This case lordship charge sheet submitted.
What is this? NDPS?
Charge sheet submitted lordship.
Commercial?
Not lordship, it is intermediate quantity.
What do you want to do? Appear there?
That lordship,
You want to appear or TCR is to be called?
TCR may be called for because nothing has been recovered from the
Charge sheet
possession.
has been submitted by CS number.
109/25 dated 21/11/2025.
Let's call for the scan copy of the TCR along with CD. List again on date.
Obliged, lordship.
41.
May I please, your lordship? The bail application, lordship. Lordship, the allegation for the FIR that lordship, I have enacted the FIR, lordship, page number 8, lordship, the type copy of the FIR, lordship. Two vehicles were intercepted by the demo police, lordship.
Lordship, in this case was 41 in 41 item lordship, charge sheet submitted.
Lordship, his vehicle was lying,
You appear there.
lordship, his vehicle is lying in the police station for last 3 months, lordship. He's
We
the
are
owner of
not
the
the
vehicle.
vehicle, we are on bail.
Lordship.
So what do you want?
There's some protection that we give him, lordship, so that he can appear for the, I also so that he can file an Zimma application for the said vehicle, lordship. Before the.
This is
Not
now
an
the main.
application for Zimma,
Lordship,
application for bail.
no, lordship, bail is gonna be, his
This is-
vehicle was hired by one Abdul
These are
Basir,
the
lordship.
cattle act. You can go and appear there.
Lordship, since the FIR was registered under non-bailable section of law, lordship, there's some cattle preservation act, lordship. And his vehicle is lying, lordship, for last 3 months, lordship. And
Talk about
his
vehicle.
vehicle
We are
was hired
not
by
on
one
vehicle.
Abdul Basir, lordship. I have specifically mentioned.
You file Zimma application. But learned counsel for the petitioner. Learned additional PP, it is submitted that CS has been submitted by CS number.
2026 dated 28/02/2026.
It is submitted by learned
20,
counsel for the
20.
petitioner that
22, no?
the petitioner shall appear before the learned trial court and apply for bail. Accordingly, the present petition is disposed of with the observation that in the event of any bail application being filed by the petitioner within a period of 15 days from today, the same shall be considered as per law. Full stop. It is further provided that during this period of 15 days, in the event that the petitioner is arrested connection with the aforesaid case, he shall be released on bail of rupees 50,000 with 2 sureties of like amount to the satisfaction of the arresting authority. The interim protection so granted shall expire upon expiry of 15 days from today. Petition stands disposed of.
Supplementary 56.
My please, lordship, can you pass over the matter for the time being? That APP as Bora has looked into that.
Order items 43.
There's a delay condemnation petition of 12 days and already 3
yes,
years
yes.
has passed.
I'm appealing for the petitioner. There is a delay of 12 days in filing the petition. I'm praying that the delay may be condoned.
Yes. We heard learned counsel for the petitioner and learned counsel for the respondent. This IA has been preferred, seeking condonation of delay of 12 days in preferring the connected revision, criminal revision petition, having perused the statements made in the IA supported by an affidavit. I am satisfied that the petitioner was prevented by sufficient cause from approaching the court within the period of limitation. Accordingly, the delay of 12 days stands condoned. The IA stands allowed accordingly. Registry to register the criminal appeal and list accordingly.
44.
I'm very grateful, Your Lordship.
May I please your lordship? As per office note dated 2026, it was fresh notice was issued upon the respondent number 2, but service report is awaited.
As per office note dated 24/26, press notice was issued on the respondent number 2 on 11/2/26, but service report is not received back. Hence, await service on respondent number 2. List again on.
Much obliged.
Item number 45.
Yeah, Lordship. As per office note dated 15/10/2025, my lord, the service to the respondent number 2 has not been received back, and also lower court record has been already received, my lord.
Seems you have not taken steps.
I may be allowed to take first steps.
Third learned counsel for the appellant TCR has been received. Petitioner to take fresh steps on respondent number 2 by speed post with AD within 3 days. List again on.
Obliged.
Even me. Forty-six.
Lordship, steps against respondent number 2 was taken on 20th of April, but through justice service, but she refused to accept it. Therefore, we have filed an affidavit yesterday. Service may be deemed to be completed, Lordship. Service admission additional affidavit of additional. That's it.
Here it was returned because of insufficient address. You were allowed to take steps by usual steps as well as dusty service. So you have not taken by usual steps by providing full address. Learned counsel for the petitioner. An affidavit on behalf of the petitioners with regard to dusty service has been filed, wherein it is stated that the respondent number 2 refused to accept service. Para by order dated 07/04/26, petitioner was directed to take steps by usual method as well as by dusty service. But steps in usual manner has not been taken. Full Sloven's petitioner is directed to provide complete address of the respondent number 2 and take press steps by speed post with AD within 7 days from today. List again on so and so. So if you have visited the residence of the respondent number 2, then you must have the full address now. Earlier it was returned due to insufficient address.
Sure.
Provide full address and take steps by speed post AD.
47.
Please, your lordship, step already taken 2 times. One is speed post, another is register post, but respondent not
Case
appear.
diary received, my lord. I can also represent, my lord. Respondent number 2, my lord, who is the informer.
Who is the OC?
Yes, he is the informant when I lost this affair. No, before that, I would like to point out, my lord, one thing, my lord, from the cause title of the present petition, my lord, that is itself is wrong, my lord. Lahorighat PS case number 191/22 under sections 420, 409, 379, 201, 34 of IPC, read with section 31 of the Assam Cattle Preservation Act 1988. My lord, this is not Assam Cattle Preservation PCA, Prevention of Corruption Act 1988, my lord. Initially, my lord, during investigation, police has seized, my lord, 24 numbers of kettles. Regarding that aspect, my lord, one case registered 186/22. Thereafter, my lord, during investigation, it came to light that the police personnel who were entrusted to investigate the matter, they sold, my lord, out of those cows, my lord, some of the cows, my lord, later on, sold 3 cows to some, my lord, to someone, my lord. Thereafter, my lord, on the basis of that, my lord, although police has OC has recovered those, my lord, sold cows later on, but FIR lodged against the police personnel who are involved in selling those cows. My lord.
Now, the present petitioner is a police personnel.
So this is not Assam Cattle Preservation Act 1988, my lord. Assam Cattle Preservation is Act of 1921. This is, my lord, Prevention of Corruption Act. Read it.
First, you have to correct this.
By hand.
Heard learned counsel for the petitioner. It is pointed out by learned additional PP that in the cause title, the matter has been wrongly shown as
Assam Cattle.
under section 13(1)(a) of the Assam Cattle Preservation Act, whereas it should have been under the Prevention of Corruption Act. Full stop. Petitioner is directed to correct the cause title by filing appropriate application. Release the matter again on. When will you file?
Want to correct by hand?
No, you have to file application.
Simple mistake only. By hand. Give a permission to by hand collect.
There are consequences for carelessness, Mr. Counsel. The sooner you learn it, the better.
One
Yes, next week.
48, item number 48.
Lordship, as per official docket 33, Lordship, notice or ID card has not been received back, Lordship, as answered.
It was way back 25/11/25. You have taken steps.
Yes, Lordship. We have
So by now, if it is not received back, you have to take fresh steps.
yes.
As per office note, ID card has not been received back. It appears that steps were taken long back on 25/11/25. Hence, petitioner to take fresh steps by speed post with AD within 3 days. List the matter again on
49.
Service is complete in this matter. This is a petition for quashing of a 498A proceeding, primarily because the matter has been amicably settled between the parties and they have filed a memo before the lower court. But just because this is a PRC case and charge sheet was already late, it could not be withdrawn. The wife has already filed a memo, which is at annexure 3, page 19, in the maintenance case, stating that she will withdraw all the cases, including the case of the instant, which is sought to be quashed here. And even PW2 and PW3 I have annexed. They have deposed in their at page 23 onwards. PW2 and PW3 has deposed that they have heard that there is a settlement between the parties.
any affidavit has been filed by respondent.
This
No, first time, I am appearing for the first time. I have not filed any affidavit, yet there is a compromise. The statement is correct. And somehow the PRC case, because of the nature of the PRC case, we could not withdraw it. And it came, the settlement came after the PW1 evidence was over. So we could not state before the court also. Subsequently, PW2 has stated that some compromise, talks of compromise has been done and it is settled. For me also, it is very difficult coming down to Gauhati from Tinsukia and for the case. And since we have already settled the dispute.
In fact, my lord, criminal revision petition not yet, my lord, registered. Filing number.
49.
Sorry, 49. 49.
Where is the compromise?
ship at page annexure 3, the petition starts at annexure 3, the memorandum of settlement, page 19. The relevant portion is at page 21, your lordship. Page 20, the grounds are enumerated. In ground number H at page 21. In view of the above settlement, the petitioner has agreed to withdraw the present maintenance case, miss case number so and so at JMFC Gauhati, PRC number 1346 of 2023, that is the instant case at JMFC Tinsukia, TS matrimonial so and so and other cases. And there was a transfer petition as well, your lordship. So all the cases are withdrawn otherwise, other than this PRC case, and the wife, the respondent herein is a service holder. I think it is inconvenience for her as well to appear before the court on every occasion. And thereafter, your lordship, at page 23, annexure 4, the deposition of the PW2 and PW3 also is reflected.
We don't know about this authenticity of this.
Lordship. PW2 lordship at annexure 4.
You file an affidavit.
Lordship. They have to file an affidavit.
Yes.
Or your lordship may record my submission on behalf of the, because I have been instructed to place before this honorable court.
No, even an affidavit, not in the affidavit before the notary, that will also do. This is a case of quashing unless we have the authoritatively that is permissible. Heard learned counsel for the petitioner, learned additional PP. Learned counsel, also heard learned counsel appearing for the respondent number 2. It has been submitted that the matter has been settled between the parties. And in this regard, a memorandum of settlement dated 18/6/25 filed before the said to have been filed before the court of the learned ZMFC at Tinsukia has been annexed. However, no affidavit on behalf of the respondent number 2 has been filed before this court. Hence, respondent number 2 may file appropriate affidavit. List the matter again on. Thanks. Give a date. Let me
Obliged, ma'am.
52.
May I please, your lordship? In this case, the service report has been returned unserved. So, in the service report, my lord, they addressed, they reported that the person could not be reached. So a fresh step may be permitted to take.
Complainant address.
In the complainant address. I'll take fresh step, my lord.
You can take fresh step, but you have to give the proper address.
Yes, I will furnish, my lord.
Learned counsel for
I'll furnish.
petitioner submits that he will take fresh steps by furnishing complete address.
Complete.
Prayer is allowed.
My lord, there is another prayer also, my lord. I have seen in the original, my lord, record, the prayer portion of interim prayer portion that was not annexed, my lord. I have already copy with me. May I be permitted to annex with that or interim prayer order? Last para, my lord. I may be permitted to annex the same, my lord. Interim prayer order.
How can you annex it?
I'll amend it, my lord, then.
It is up to you. We don't, it doesn't, no observation of the court is required as and when you
Yes,
file.
yes, my lord.
There is allowed to list the matter again on. 4 weeks. After 4 weeks.
Yes, my lord. Date. Date may be fixed. Obliging, ma'am.
53.
May I please, Your Honor? I'm appearing for the appellant, my lord.
Hmm?
For the appellant, my lord.
Yes, I can see that.
We have already taken the steps.
It appears from office note that steps have been issued on 13, a notice has been issued to respondent number 2 on 13/3/26 through CJM Sri Bhumi by speed post. But no report of service is available. Await service report. List again on. Will be. Fifty-four.
Thank you.
My lord, I am sorry to disturb you, my lord. Item number 52, I will take step through speed post, my lord. DJ ST will take speed post service.
You already.
52.
Step by speed post. AD. Speed post AD.
Before I am appearing for respondent number 2, lordship.
Mm.
May I please, Your Lordship, 528 application for quashing of disproprious 66 of 2026, Lordship.
Yes, there is one.
Lordship, Lordship, the perks of the matter is that the petitioner and her and the complainant were in relationship. And the petitioner here, the petitioner came from Rajasthan to have a court marriage with the complainant, which took place on January, 28 January. Later on, he astonishingly he discovered that she was married and she was not legally divorced with a previous marriage, and which astonishingly the marriage took place last year. The previous partner was November. And she has, I am falsely implicated in this case, so I prefer this petition to quash the FIR. You have anything to say? The photo proof is in page number, Lordship, may can be come to page number 24 to 23rd, 23rd and so on. 23rd to 26 is a picture of previous marriage, which was held last year, November in Rajasthan. Then on, she concealed the marriage and we got married in January, which is in page number 22, fourth marriage, January 28th. And after discovering the pictures of her photos, she implicated me in this case, section dispute PS 66 of 2026, Lordship. And then and I tried to lodge a cross FIR, which the dispute police station denied, Lordship.
Lordship, may I kindly come to page number 6 of my petition, 6 and 7, paragraph 12.
Yes, paragraph.
Paragraph 12. Page number 6 and 7, paragraph 12. Then on the complainant here went to Mahila police station to complain, but the Mahila police, they found inconsistency in her statement. The complainant and her uncle, the statement. So the petitioner here was advised to go to the Dispur police station to lodge a complaint. Then a cross-FIR was lodged against the lady. And Dispur PS 80/2026 was registered under section 61, clause 1, section 318, clause 2, 82, clause 2, and 308, clause 3. Chief.
You are on bail.
Yes, Lordship, I'm on a PR bond, which the debt was fixed yesterday in the lower court, Lordship. But as per the last order, in the Justice Franjal Court, I've requested for adjournment yesterday in the lower court, but
Charge sheet has been filed. No.
Lordship, charge,
It's
yes.
going on, both two CDs were called for, both CD I have received.
Both the cases have been registered.
Yes.
So what transpires from that? He is earlier married.
My lord, regarding that aspect, but marriage certificate with the present petitioner in the first case, that is available in the case there. But regarding whether she was earlier married, your lordship may kindly peruse the statement of the, there was no such legal marriage probably taken place between the.
No, you just say what is
Yes.
there.
Ceremonial
Your lordship may
marriage
kindly
was
peruse
conducted.
her statement in the cross case filed by the petitioner. ma'am.
The picture itself, photograph itself
would
said
be-
there was a Hindu ceremonial marriage, Lordship.
Does she say anything about the previous marriage? No.
She stated that initially, my lord, yes, your lordship may kindly peruse first fourth line, my lord. But there was no such legal marriage which, as alleged by the present petitioner, that with one Pawan Kumar, my lord. But regarding that aspect, till now, from investigation, there is no such proof, my lord, yet revealed, my lord. This case is very recently registered, my lord. Only first FIR lodged by the respondent only on 24/3/26.
Lordship, the Mahila police station have called Mr. Pawan Kumar and confirmed that there was a marriage.
Regarding that aspect,
already.
there is no note of the
And
IO, my lord.
petitioner was asked to lodge a cross FIR for that reason. The picture itself, the photograph itself clearly says that there was a Hindu ceremonial custom traditional marriage.
From her statement, it reflects that there was no such legal marriage took place between the, my lord, the victim and one Pawan Kumar, my lord, as alleged by the petitioner here in my.
Present sections are
Yes.
relating to what offense?
By giving.
Well, no. Yes. Well, section 109 attempt to murder, 1152 that is voluntarily causing hurt, and 351 3 criminal intimidation, and 85 cruelty by a husband or any relative.
So even if you had an earlier marriage,
Yes, Lordship.
what
Lordship,
does it matter? These are independent offenses.
yes, Lordship, but when, please come to page number 29. The lower court has observed page number 29 of the lower court order. Page number 29
Still states-
says, the Ijara does not attract provision of section 109 of the BLS. Page number 29 of sorry. Annexure F. (109) is not it.
Bail petition was filed by the wife of the accused.
Yes, regarding that aspect also, my lord, because he assured, my lord, because legally marriage took place between the present petitioner and the, my lord, accused person. And regarding that aspect, certificate is also there. At that point of time, he assured that you please, my lord, do this bail petition on my behalf, then I will again, my lord, live with you peacefully. And on that aspect, my lord, on that assurance, my lord, she again filed that bail petition on his behalf. That is there in the, in her statement also, she stated about filing of the bail petition on behalf of the present accused.
Lordship, the petition.
Otherwise,
the
the investigation is at the very initial stage. FIR laws only on 4/2/26. And the FIR, so at this stage, my lord, and regarding other aspect that whether the, my lord, respondent herein, that is victim was earlier married or not, my lord, regarding that aspect also, my lord, police need to collect those evidences in respect of others. Yes.
Pending for respondent number 2, Lordship. As per her information, Lordship, this the petitioner is seeking her 2 times applied for marriage before the Kamrup registry, Lordship. Thereafter, one boy. And she said actually, proposal has come from their house, Lordship. And Haldi Rosam completed, then he said, no, I will pay. Then he again come to Gauhati and marry. He, from the first, his motto is to cheat her.
No, Lordship, they could have married in Rajasthan. They could have married in court marriage in Rajasthan also. But to satisfy her,
No,
to
it
do,
completed, Lordship.
like,
Haldi Rosam completed
she-
as per her.
he came to Guwahati and he was falsely implicated in this case. Marriage was done in 28 January and on 2nd he lodged an FIR. She lodged an FIR. And I was kept captive in the hotel, Lordship,
Her complaint is.
in Ganeshguri. Because I'm new, so I'm new to
Her to
Guwahati,
be-
so she and her uncle took advantage of me, Lordship. This is completely misuse of women-centric laws, Lordship. And I'm a victim of this, Lordship.
Yes, Lordship, at this stage. Not be quashed, Lordship. Let him face the trial since he is in bail. Coming to next step, I shall produce the earlier marriage application with petitioner version. 2 times he cancels the marriage version.
Lordship, if we come to page number 37 to 40, it's my FIR. She and her uncle held me captive and seized all my documents, all my possession. And I was taken from court to hotel from the place I was captive. And later on, she still has some of my documents seized with her, Lordship, which she have not given to me also.
All right, if you want to furnish something, then
Completely.
we'll have it on another date.
What documents want?
He applied for 2 times, Lordship.
Lordship, that's for applying
Otherwise,
for
well,
court marriage.
only her verbal submission that victim was earlier married, that will not do. That. First,
No,
well,
the
where is the evidence that she was, and even if my lord, she was earlier married, then also the present accused lured her, thereafter, my lord, taken her to here, thereafter legally married, my lord, regarding that marriage certificate is also there, my lord.
That's court marriage, Lordship, which was done. I don't deny that. There is no dispute of page number 20.
This is whether, my lord, those sections are attracted or not, my lord. Well, those things will
But
reveal
page
only
number
to-
22 to 26 clearly it says that she have already have a marriage earlier and which was held November last year. And she came here uh, and she married on January also. This is completely misuse of women laws, lordship, provisions of laws for protection of women. And I'm a victim of this lordship.
Dowry also demanded.
And her address is also
To
at
the
my.
Pawan Kumar also, he has demanded a dowry. The previous one also.
And well, your
And
lordship may
because of
please
that-
see the office note dated 2/24/26.
Lordship, I
Although my
may-
lord, in this case, my lord, although legal counsel has been appointed by the legal service authority, her address is from my lord, from Potasil Ambari. Till now, that notice not yet served to respondent number 2.
We have served, as per the last order, we have served, and for that she has approached the DLSA.
Yeah. See approach.
Yes, yes. The respondent has approached the DLSA. Last she had received the notice. Lordship, if I may be allowed permitted to place one case laws.
You are appearing as amicus.
Legal aid counsel.
Legal aid
Appointed by
counsel.
the Gauhati High Court Legal Services.
So are you in contact with the party? Then that's okay. Oh.
And with regard to the court marriage, which she applied for
Today I filed
twice.
memorandum of appearance with the appointment letter, lordship, because normally.
So you want to file some objection?
Lordship, and they have sent me a settlement notice, which is in 12th. Now she will falsely implicate me and she wants to settle. We have received the notice. The paper is not with me. There is
This has been issued by whom?
DLSA that they want to settle.
All right, if they want to settle, get
But
it
she-
settled. What is the difficulty?
I'm facing unsettling harassment and they want to settle. She falsely implicates me and now she wants to settle. So
She's thinking of her life for better life. If
She married-
If the husband is
At least you have another window to escape now.
yes, Lordship, that's the reason.
So
but
why
I-
don't you go for settlement?
Unnecessary harassment I have faced now. Again, I have to come back from
No,
Rajasthan.
No, what we are saying is,
sitting the.
you have an offer of settlement.
Yes, Lord.
Go and talk, see what they want.
Yes, Lordship.
Otherwise, you cannot be certain that you will succeed in the present petition.
Yes, Lordship.
So why not take all the available options that you have?
Yes, Lordship, that we will do, but
All right, when is the date for settlement?
12 next month it's given, right? 12.
Right,
It's given, yes,
learned
12.
counsel for the petitioner and learned
Held by the.
additional PP also heard learned legal aid counsel representing the respondent number 2. It is submitted that the petitioner has received a notice of settlement from DLSA Kamrup
Yes, Lordship.
Metro.
I think from the DV case, lordship. One DV case is pending, lordship.
All right. In respect of a, okay, that you're not certain. And the date for settlement is fixed on 12th,
Yes, sure.
12th of May.
Yes, Lordship.
12th of May. Further, learned legal aid counsel also praised for time to file objection. Having regard to the above, release the matter again on 18th of May.
Okay. Lordship, I may submit one again on order as last order that's 6-4. In the last third line, last
Yes.
line, it is open for the petitioner to bring the safe fake about the pendency of the petition and adjournment today. Yesterday it was fixed in the day before yesterday it was fixed in the lower court, but the judge was confused about this line adjournment today. It should be adjournment of the day or last order, that's 6. Or the order of that 6th.
If he is confused, let him remain confused. We have said what we have said.
Okay, Lordship.
Yes. CD, what will you do? Send it back. Send back the CD. To be resubmitted on the next date fixed.
56 standing at.
Obliged, Lordship. Much obliged.
May I please, Lordship? So. Transport record was called for Lordship.
Lordship, here,
Here has come. Now the case is pending at the stage of framing of charge. The charge has been framed and now the case is pending at the stage of evidence. Lordship.
yes. The offense under section 21B, Lordship.
Prima facie case is established thereafter, Lordship, charges has been framed.
Lordship, already 80 days behind in bar, Lordship.
Gravity
He's a
of the
local-
offense as well as the materials available on record.
He's a local resident of Lordship, Nalbari district, Lordship. He will appear.
And the
Lordship.
contraband has been recovered from the conscious position of the petitioner also. 2.27 grams of heroin, Lordship.
Where's the file, Lordship?
The relevant witnesses be examined, Lordship, first. Let the relevant witnesses be examined, Lordship, because it
It's
is
already
recovered
80
from
days
this
behind in
conscious
bar,
position.
Lordship.
You kindly consider the gravity of the offense as well as the materials, incriminating materials available against our petitioner.
You ran away after parking the scooter and you still had it in your hand, the heroin. You could not throw it away.
Lordship. Lordship, he will face the trial, Lordship, a local resident of the north, of Nalbari
Yes,
district,
Lordship.
Lordship. He will face the trial, Lordship.
Let the relevant witnesses be examined first.
Lordship, he will face the trial, Lordship.
It's a conscious position, it's a
He will appear, Lordship.
grave offense, Lordship, against a society at large. Lordship.
Lordship, he will, at any condition, Lordship, he will appear, Lordship, each and every day, Lordship. Local resident of Nalbari district, Lordship.
Exacting, Lordship.
Lordship,
All right, we'll see.
Lordship, young boy, Lordship. He's a young boy, Lordship. His sons may be given.
Is the only one person from whose
Lordship.
position it was required.
Lordship,
It was conscious position.
kindly consider, Lordship, kindly consider at any condition, Lordship.